first item of business, and I want to thank, we've got some students, it looks like, in the gallery there. So does someone want to tell us where you all are from, or where are you all from? Grain Valley, what? Smoky Valley. Well, thank you for coming to the Capitol today, and hope you enjoy it. Thanks for coming to committee. With that then, committee, are there any bill introductions? Yes, Senator Stephan.
Senator Mark Stephan, thank you for allowing me to be here. I'd like to read in RS 2734, RS 2735, and RS 2763. Would you like a brief description, or are you good to go?
A brief description, yes, please, of each of them, Senator. Thank you.
RS 2734 involves the state capitol and the capitol remaining open to the public in particular times. 2735 concerns the freedom of worship. And 2763 is a bill concerning restriction of business activity.
Thank you. The bills will be so introduced.
Thank you.
Thank you. Any other bill introductions in the committee meeting room or online? I do have a couple myself. They are 22 RS 2804, which increases the criminal penalties for multiple thefts of mail, and 22 RS 2528, which concerns rules and regulations and gaining back a legislative authority from bureaucrats and the overreach there. So with that, then, those two bills are so introduced. Any other bill introductions? Seeing. And I wanted to point out, thank you, Mr. Revisor, wanted to point out that the second bill, 22 RS 2528, is a concurrent resolution. With that, then, we will turn to the next item of business, and we will open the hearing on SB 300. If we could have a bill brief from the Revisor. It amends the Kansas Racketeer Influenced and Corruption Organization Act. Thank you, Mr. Thompson.
All right. Thank you, Madam Chairperson. Good morning, committee. As you heard, Senate Bill 300 is an act concerning the Kansas Racketeer Influenced and Corrupt Organization Act. That's the Kansas Rico Act. And the changes are to add a person who is engaged in identity theft or identity fraud to the definition of covered person under that act, and also add identity theft and identity fraud to the definition of racketeering activity under the act. The amendments are to KSA 21-6328. It's a fairly lengthy statute that provides the definitions to be used in the Kansas Rico Act. You can see that the definition of covered person is expanded to include any person who is engaged in or is engaging in conduct prohibited by KSA 21-6107. That's the crime of identity theft or identity fraud. And then the definition of racketeering activity, you'll see, is expanded to mean to commit, attempt to commit, conspire to commit, or to solicit, coerce, or intimidate another person to commit any felony or misdemeanor violation of identity theft or identity fraud. And it fits in a long list of other violations that are also listed as racketeering activity in the current law. I put a note in the bill brief and just wanted to mention to you that this does not affect the elements of a RICO violation, just the definitions of what crimes sort of trigger the violation. KSA 21-6329, the next statute in RICO that's not in the bill, actually makes it unlawful for covered person to do one of three things, and I spell those out in the bill brief if you'd like to look at that, or look at 21-6329 itself. Essentially, racketeering requires a pattern of racketeering activity, so it's triggered off of this definition. So the pattern requires multiple incidents over a span of years, and so in this case, one of those incidents or criminal activities could be identity theft or identity fraud, right? So you still have all the elements required under RICO of an enterprise, ongoing pattern, multiple years, et cetera. But one of the things you could be doing that would trigger a RICO prosecution would be identity theft or identity fraud. So that's the point of the bill. I'll stand for questions.
Thank you. Would it have to be multiple incidents of identity theft? Because we've got multiple pattern, it would have to be more than just one, is that right?
Thank you, Madam Chair. Yes, so I was mentioning that essentially any of the crimes listed in racketeering activity would count. So if you have identity theft or identity fraud is one of them, but you have, say, collecting an unlawful debt or this theft of vehicles, whatever. So one of the incidents could be identity theft or identity fraud, but any number of incidents that add up to racketeering activity could be used against you. And then the definition of pattern is the other one that's key. And that one is on page 2 in the bill. Pattern of racketeering activity, that's 2 incidents of racketeering activity that have the same or similar intents, results, accomplices, etc., and are not isolated incidents, provided at least one of such incidents occurred after the effective date of this act and the last occurred within 5 years. So the Rico Act has a number of separate sort of hurdles before you can actually charge someone with it. So you have racketeering activity, which is the crime, and then you have the pattern of it, which requires multiple incidents within a 5-year period and not isolated incidents, right? They have to be similar intents, results, accomplices, et cetera. So that essentially you've got an enterprise, a criminal enterprise that is doing a number of different criminal activities, and that's what you're trying to punish. So hopefully that clarifies it. This is part of a much bigger bundle of offenses.
Correct. Thank you. Committee, questions for the reviser? And thank you for that clarification. Seeing none, then we will ask our, just a minute. We will ask our proponent, first proponent, testimony from Senator Mike Peterson, the 28th District, Kansas State Legislature. Welcome to committee, Senator.
Thank you, Madam Chair, members of the committee. I appreciate you accommodating my trimmer by allowing me to testify.
Could you just make sure you speak into the microphone so those following online can hear you as well, Senator?
Thank you. I just want to thank you for accommodating my trimmer today, and I appreciate you letting me testify sitting down. Adding these to the Rico Act came about after a year ago when we were talking about the unemployment fraud. I thought, why don't we have identity theft? I started getting this drafted and moving forward with it. The committee took care of it last year. This bill came out late, and so that's where we're at. Back in 2005, the entire Senate met in this very room for a special session. During that special session, there was a lot of time between the House and the Senate where you were down and just sitting there reading. I started reading Supreme Court cases. Of course, everybody was interested in Montoy. I came across one that was State v. Martin. It was on identity theft. A young man had organized a group and had these people out there stealing identities, and he coordinated when to buy stuff, when to resell it, when to use the identity, and they were doing an upward departure on his sentencing. Well, our statutes didn't allow for that, and so they had to fix that. We fixed that subsequently in 2006. One thing that caught my attention was Chief Justice McFarland, in her comments, said it would be very rare for one of these cases to be prosecuted in the state of Kansas. And I thought about that, and I didn't understand fully why, but then last year when I started looking into the penalties, where identity theft is just a presumptive probation up to $100,000, and it's only a border box when you go over that. So you'd have a person organizing it, taking it all the way through, and the effect of everybody is a lot on the community, on the prices of things, the banking, and all of that. And so I thought, we ought to figure out a way to get this. Well, kind of like Al Capone when he was running liquor during Prohibition, if you take out one of his drivers, you're not going to slow up the organization. But I thought this would be a way that we could get to the CEO or the ringleader of the group and maybe make an impact and stop some of the identity theft. It won't be used for everyone. Most of these cases will probably be prosecuted under federal law. But if you have to prosecute underneath the federal Rico Act, every time you want to serve a warrant, you have to have a federal sponsoring agency present. If you're in a small community like Dodge City, all your pre-trial follow-ups and all that, you have a lot of drive time going back and forth. But if it's the state level, sorry, it would let it come. I mean, this is just crazy that you could have all these crimes come together. Someone could be stealing $1 million for 10 or 11 people and only have presumptive probation. Imagine our justice system sitting there trying to finding these crimes where there's a pattern of them. They're going on, they're doing this. You go in and negotiate with the person to try and get who the leader is. And you say, well, you're facing presumptive probation. I'd like you to tell me who your leaders are, who you're working for. I can give you maybe presumptive probation and a cup of coffee. I mean, that's just not going to work. But under the Rico Act, they could prove that pattern and they'd be facing 2 years and it'd be more apt to talk and maybe move forward. It's just trying to get this crime in there into that pattern and to make it work. And I hope it's never used, but you just never know. With that, I'd stand for any questions.
Thank you, Senator. We'll hold all the questions till after all the proponent testimony. And then we will now invite Mr. Greg Smith, Special Deputy Sheriff for Government Affairs, Johnson County Sheriff's Office, to the podium. Welcome to committee.
Thank you, Madam Chair. It's good to be back in Judiciary. I am Greg Smith. I'm the Special Deputy for Government Affairs for the Johnson County Sheriff's Office. We are in support of this bill for many of the reasons that Senator Peterson just mentioned. Our research into identity theft in Kansas shows that we're in the top 5 out of the 50 states for this, in large part to last year's unemployment mess. But in Kansas, roughly, there's 187 victims per 100,000 citizens. So as you can see, that quickly adds up. This would give prosecutors and law enforcement a tool where we can move to combat these types of crimes. They are often organized enterprises where your identity is sold on the dark web for multiple purposes, and you go to try to buy a car or refinance a house and all of a sudden find out that your credit has been totally destroyed. It takes a long time to recover from this. There isn't much we in law enforcement or prosecutors can do to help people in that recovery, but it's a very devastating crime, and we stand in strong support, and I'd be happy to stand for questions at the appropriate time.
Thank you, and wanted to mention to committee that Mr. Smith is a former senator as well, and also comes to us from my home district, my home area in Johnson County. So thank you for coming to committee today. With that, committee, we will ask then for, are there any more proponent conferees in the committee meeting room? Seeing none, then any online? Seeing none, we will then go ahead and open it up for questions for our proponent conferees from the committee. Committee, any questions? I don't see any, but do want to thank both Senator Thompson and former Senator Mr. Greg Smith for taking up this issue. We have heard a lot about the unemployment fraud in particular here in Kansas. I'm concerned, I guess, that we're one of the top 5 states where we have this issue before us, and it's important to give our prosecutors, our law enforcement community more tools to stop this kind of crime in Kansas. Wanted to also point out to the committee that in your committee folder, we do have proponent written testimony from Mr. Steve Kearney, Executive Director, Kansas County and District Attorney Association, and from Ed Klump, Legislative Liaison, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. I don't see on the agenda that we have any neutral conferees scheduled, but do we have any neutral conferees in the committee meeting room or online? Don't see or hear any. How about opponent conferees? I don't have any on the agenda, but do we have any in the committee meeting room or online? Do not see any. So with that, committee, then, if we don't have any further questions for our proponent conferees, we will close the hearing on SB 300 and thank our conferees for appearing in committee today. We will then turn to opening the hearing on SB 321, prohibiting the use of restraints during hearings under the revised Kansas Juvenile Justice Code. And we will ask our reviser, Mr. Thompson, to provide the committee bill brief. Thank you.
All right. Thank you again, Madam Chair. And before I forget, I just wanted to remind the committee that Senate Bill 300 was a carryover bill. There are a couple of 2020 dates that would need to be 2021. So if you do work that bill, I'll have a technical amendment that I would recommend that you adopt. So didn't want to forget about that. And yeah, just wanted everyone to know that might be coming. All right. So then Senate Bill 321. This is a new bill, so no issues with with dates on this one. This is a bill introduced by the Joint Committee on Corrections and Juvenile Justice Oversight, one of your interim committees, and it was one of two recommendations that they made. This would prohibit the use of restraints during hearings under the revised Kansas Juvenile Justice Code, and would also authorize some exceptions to that prohibition if the court holds a hearing and makes certain findings. So this is a new section that would be added to the Juvenile Justice Code, and the court is basically required to hold a hearing to authorize the use of restraints. You have to make certain findings on the record that those restraints are the least restrictive means available and are necessary for one of the three reasons given in the statute, either to prevent physical harm to the juvenile or another person during the hearing, a well-founded belief that the juvenile is a substantial flight risk, or that the juvenile has a recent history of disruptive behavior that has placed others at risk of substantial physical harm. This can be requested, the use of restraints can be requested by the court on its own. It could be requested by an officer of the court or maybe even a prosecuting attorney. And they are all allowed to be heard by the court before making that ruling on the use of restraints. If the court does order the use of restraints, they have to make written findings in their order, and they have to order the least restrictive restraints necessary and allow the juvenile to have sufficient movement of the hands to be able to read and handle documents and writings necessary for the hearing. The other section in the bill, Section 2, amends the definition section for the revised Juvenile Justice Code 38-2302. That, of course, is a long statute. It has a number of definitions that are used throughout the code. And we add two. We add hearing, which means any court proceeding held under the code. So it's very expansive, includes detention, first appearance, all the way through sentencing hearings. So that would be when this prohibition would apply, any of those appearances. And then restraints are defined to mean handcuffs, leg shackles, leg irons, many things you would think of, or other restraint devices used to restrict a juvenile's free movement of limbs or appendages, including those made of cloth and leather. So there's a very expansive definition of what it means to be a restraint under the code as well. And then finally, the third section of the bill is a simple amendment to KSA 38-2353. Again, part of the Juvenile Justice Code. It has its own definition of hearings, which will no longer be needed because the definition that we put in Section 2 will take its place. And they're nearly identical. So we don't really change the definition of hearing. We're just moving it earlier in the code so it can apply to multiple sections instead of being stuck down in 38-2353 kind of all by itself. So it's more of a cleanup amendment than anything. I think that covers it. I'll be happy to stand for questions.
Thank you, Mr. Thompson. Committee questions? Senator Pyle.
I don't know whether this is for Mr. Thompson or for research, but is there a fiscal note on this bill?
Ms. Nelson, are you able to answer that?
Madam Chair, yes, there is a fiscal note. It's on the website. Do we not have it in our? We can print off some copies and bring that up for the committee.
Thank you. Thank you.
Thank you. Committee, other questions for the reviser? Seeing none, then, thank you, Mr. Thompson. We'll then invite Eileen Burquist, Community Engagement Manager, ACLU Kansas, to provide testimony. Welcome to committee. Please introduce yourself.
Thank you, Chair. Oh, I'm a little bit shorter than the folks who came before me, excuse me. Thank you for the opportunity to present today. My name is Eileen Burquist, and I'm the Community Engagement Manager and Lobbyist for the ACLU of Kansas. We are a nonpartisan, nonprofit organization that works to preserve and strengthen the civil rights and liberties of every person in our state. I also want to thank the JJOC for bringing this bill to the committee's attention. The ACLU of Kansas supports the passage of the proposed bill prohibiting the unjustified shackling of juveniles appearing before courts. Shackling children causes physical and emotional damage while creating bias against them in court, infringing upon their rights by undermining their presumption of innocence. I'll skip ahead. There are some great references in here for those folks who would like to look up on the physical and emotional toll this takes on our children. But I would like to focus on the fact that this is not necessarily a controversial bill. Currently, 32 other states and the District of Columbia limit or prevent the use of cuffs and restraints on juveniles appearing in court. Legal organizations have also weighed in. The National Council of Juvenile and Family Court Judges has noted that shackling of children infringes upon the presumption of innocence, undermines confidence in the fairness of our justice system, interferes with the right to a fair trial, and can limit the child's ability to engage in the court process. As a result, that group of jurists has called for a presumptive rule or policy against shackling children. Similarly, the American Bar Association has called for a presumption against the use of shackles and restraints on children, noting that the practice is contrary to law, interferes with the juvenile's right to participate in their own defense, runs afoul of the purpose of the juvenile justice system, and is ultimately unnecessary. This bill is a necessary and just change to our current code. There's no reason for Kansas courts to automatically shackle and restrain children appearing before them. This bill would end the practice except where absolutely necessary, and in so doing protects the health, safety, and civil rights of children appearing before our state's courts. So thank you for your time and the opportunity to speak here today.
Thank you. In committee, we will take questions for all our conferees after we have heard from everyone. Thank you. We will then ask Mike Fonkert, Campaign Director, Kansas Appleseed Center for Law and Justice. Please introduce yourself and welcome to committee.
Thank you, Chair Warren and members of the committee. My name is Mike Fonkert. I am the Just Campaign Director with Kansas Appleseed, and we are here to support Senate Bill 321. Special thanks are in order here to the Joint Committee on Corrections and Juvenile Justice, Senator Baumgardner, Representative Owens, and all the members of that committee. I want to thank them for taking up this issue, elevating it, and ultimately recommending that the legislature bring this legislation. As you've heard and as you can see in much of the written testimony that is provided for you today, this is a bill that would put Kansas in community with 32 other states and the District of Columbia. Those states, the majority of them, have updated their codes with respect to restraints of youth in court within the last 10 years. So this is a particularly relevant topic and one where Kansas is just lagging behind. We currently have no laws, no state statutes that really dictate any rules around when a child would be shackled in court. And so it ends up being the discretion of those individuals that bring a child into court, et cetera. And so this just establishes a procedure. As the previous speaker noted, this does not prohibit all cases of restraining a young person in a courtroom setting, but does create the presumption that that children would not be restrained unless warranted and unless the court deems it appropriate. So, you know, this is pretty straightforward from our perspective. You know, adults via the Supreme Court and Kansas law enjoy presumptions against restraints in court in a variety of ways where children do not. Shackling of children can be humiliating, degrading, and children are particularly susceptible to the emotional traumas that shackling and restraints in court can cause. With that, I think I will close, and again, just thank the committee and that joint interim committee for elevating this issue and putting this bill forward, and would be happy to stand for questions at the appropriate time.
Thank you. Committee, please turn and look in your folder. We have proponent written testimony from the Honorable Jennifer J. Ashford, 10th Judicial District, from Christina J. Gilbert, Senior Youth Policy Council, the Galt Center, from Jeanette Bottler, Deputy Director, Justice Action Network, Jessica Fireman, Managing Director, Juvenile Law Center, and Allison Clements, Director, National Juvenile Justice Network. Do we have any other in-person, either in the committee meeting room or online, who are proponent conferees? I don't see any, so then committee, we will open it up for questions for our proponent conferees. Yes, Senator Wilborn.
Thank you, Madam Chair. I would like to, I'll ask Mr. Funkert a question as it relates to, can you be real specific and give me an example of when shackling would be appropriate?
Go ahead, Mr. Fonkert, please introduce yourself. Thank you.
Mike Fonkert, Campaign Director, Kansas Appleseed. Thank you, Senator Wilborn, for the question. A very specific incident when a child would be shackled. So, as you can see, there are three different situations, I guess, in which that could happen. So, for instance, if you have a child in custody that is demonstrating consistently disruptive behavior, violent behavior, that would be criteria that the court could then consider to restrain that child in the court. Being a substantial flight risk, I think is pretty straightforward. If the child is a chronic runaway, has tried to escape various facilities, that could be entered into the record. So that child would be restrained in court. But again, yeah, the presumption is that wouldn't happen, and some extraordinary circumstance would be present that then could be considered so that a child would be restrained.
I have a question for you as well along those lines. So if the bill were to be enacted and the presumption is to not shackle the juvenile, who would bring the motion to the court to overcome the presumption this juvenile in this instance should be shackled? Who would bring that kind of motion?
It can come from a variety of sources.
Oh, go ahead and introduce yourself, please, for those following on.
I'm Mike Fonkert again, Kansas Appleseed. It would come from a variety of, could come from a variety of sources. The court itself, the judge could deem, based on history of the case or involvement with the youth in some way, that they decided to bring that. I think the most likely place for that to come from would be a prosecutor or a court service officer that has been interacting with the case with the child in some way to know that background.
How has that process, is that process in place in other states?
Yes, absolutely. So the 32 states we mentioned in District of Columbia all have very similar laws in terms of the presumption of not restraining and a process that has gone through to request restraints.
How are those requests? Are they often granted? Are they denied? What kind of percentages do we see as a result of those motions?
Yeah, so I don't have specific percentages, but I think what we see in Kansas is that, just referencing back to the National Juvenile Defender Center's assessment in 2020, now the Galt Center, they've renamed themselves, we saw they did a lot of courtroom observation, and they saw a lot of youth that were restrained in court. But when they talked to people involved in the system, they thought that shackling wasn't a big issue, though when they did their assessments, they found many examples of it. And so I think that just kind of highlights the point that it is, even now, more rare. It's not necessarily the norm that young people are shackled, but this creates the the rules around it so that each court will follow that in the same way. As it stands now, I know there are courts like in Johnson County where they have enacted local rules for the presumption not to shackle or restrain a child. And so can't really speak to percentages, but I think it is very reasonable to assume that if someone puts forth the motion to have a child restrained and has some sort of reasonable basis for that, that the court would act accordingly and likely grant that request.
Thank you. Committee, other questions? Seeing none, then, we will turn to neutral conferees, and we have in person in the committee meeting room, Mr. Greg Smith, again, with the who is the Special Deputy Sheriff for Government Affairs from the Johnson County Sheriff's Office. Welcome back to committee.
Thank you, Madam Chair. Our concern with this bill, and to be very, very frank about
Go ahead and introduce yourself. I'm sorry.
Pardon me?
Go ahead and introduce yourself again, please.
I'm
Thank
sorry.
you.
I'm still the Special Deputy for Government Affairs, Greg Smith, with the Johnson County Sheriff's Office. We had a big discussion at our office about this on which way to go, and we decided to go neutral, but in total frankness, we're leaning towards opposition as the bill is written for the concerns that I'll outline. Number one, deputy sheriffs, at least in our county, are charged with courtroom security, and we're concerned that this bill could hamper our ability to do that. There's many factors that this bill talks about that could be introduced in court. Some of those factors the court may not be aware of, the district attorney's office may not be aware of because they don't observe the juvenile in custody. For that matter, deputy sheriffs rarely do either. That falls under juvenile corrections. But if the report is made, it takes a while to wind its way up to the DA office. They may not have that information when they get in front of the judge. They may not be able to make the appropriate motion if they don't have the information. We're concerned about the language that the only person that can make a motion is an officer of the court. By strict definition, deputy sheriffs, juvenile corrections officers are not officers of the court. If there's a transport incident, if something happens on the way to court, there's no means of relaying that information to the court as this bill is laid out. Lastly, we're concerned about what the bill doesn't say, which may be more important than what it does say. There's nothing in this bill that's completely silent on does this hamper our ability to take action in court if one of these actions, if some type of action happens where that person needs to be restrained. They aren't restrained, something happens, there's an outburst in court or whatever, and can we take action or are we forbidden to do that under the law as it's written? So for those reasons, we're neutral on the bill, concerned about those issues, and we'd ask that you please take those into consideration, and I'll stand for questions at the appropriate time.
Thank you, Mr. Smith. We don't have any other neutral conferees who are present today. We don't have any in the committee meeting room, do we? I don't see any on the agenda either. So if you'll just stand for questions now, I think we have one from Senator Pyle. Thank you.
Thank you, and thank you for your testimony. I'm curious, since what you're saying, would there at any time, if a juvenile was not restrained, what's the risk while the bill kind of is limited to the courtroom in those areas, but what about in the transport? Is that not covered in the bill? I mean, would you be able to restrain in transport or not under this legislation?
Thank you, Senator Pyle. Our understanding of the bill is this only concerns the courtroom itself, not the actual transport to the courtroom.
Okay. And I noticed on the fiscal note that it says in the third paragraph that it could increase expenditures because it would require an additional hearing and specific court finding. But I also noticed too in the opposition testimony that's in our packet that's written that they say it will undoubtedly cause further expense to the judicial branch as well as additional prosecution and defense cost. I don't see how I can understand because it's saying that most of this cost is on the counties. and is more local than what it would be to the state, the court costs are borne by the locals. So, I mean, I guess I'm asking, in your opinion, is there a pretty substantial fiscal note to holding those hearings and making the determinations that they're asking for? And if so, and that's the fiscal note of it. The second question is, is there a possibility out there that the judiciary, based on that fact alone, that there is a cost, would say, we're not going to do that, we're going to let them come unrestrained? I'd like to hear your comments.
I mean, there's, obviously, if there's another hearing, then there's a cost that's associated with that hearing. Anything from security, from the sheriff's office to whatever expenses the court has to bear for those hearings.
Okay. And do you think there is any possibility that the court or the judiciary could just not do the inquiry and no one would ask for those restraints because they would be required to go through those hoops?
Like I know that's our tough. Concern is that any kind of motion has to be made by an officer of the court, and we're not. So unless we can get to the DA before the hearing or something like that and let them know, hey, there's been an issue or something, it would be hard to make that motion. Then you'd have to, at least at the way court works now, there'd have to be a motion hearing scheduled. I don't know if that would supersede the hearing that we had brought the person over there for. So, I mean, there could be costs associated with that.
All right. Thank you. Thank you, Madam Chair.
Thank you. Committee, other questions? Senator Gossage, then Senator Corson.
Thank you for being here. What I'm hearing you say is that not that you would make the determination, but that you would like to present this to someone so that they could have the information. Perhaps this juvenile was, the fear is that he would be destructive or flight risk or, harm somebody else or himself. I could see that to be a rare situation. Would you agree?
I mean, those situations happen. Are they frequent? Not necessarily,
okay.
But they have happened.
But they have happened. So, and you said you may have to try to catch someone, like before the court starts, try to real quickly catch somebody. Would there be an amendment that your organization would be more comfortable with this bill?
That's a great question, Senator. We actually hadn't looked at any alternative wording. We were just more concerned with airing our concerns.
Mm-hmm. Thank you.
Thank you. Senator Corson.
Thank you, Madam Chair. I'm actually glad Senator Gossage asked that first because my question was kind of along those lines. Wondering if there could be an improved sort of internal communications mechanism so we could more quickly get concerns that are raised, within the facility or the detention center to our courts or district attorneys. But I mean, it seems like maybe that's something that we could overcome just by having maybe better a process or procedure where those issues could be more readily surfaced to a court or district attorney. Do you have any thoughts on that? And then my second piece of that is that, I mean, in Johnson County, the presumption is already that youth appear without restraints right now. So I don't think this bill would really affect you in Johnson County unless I'm misunderstanding, because my presumption is that this bill is essentially already being implemented in Johnson County. So is your concern about how it would affect other counties? And I apologize that those are two questions, but I wanted to ask both of them. Thank you, Madam Chair.
Well, the concern is, thank you for the question, Senator. The concern is that, yes, we do have a policy in place that works the majority of the time. This would supersede policy. So are we going to have to stop things that we're doing because of the way this law is written? Because it's silent on things that we do now. It doesn't say you can, it doesn't say you can't, and so we're kind of in limbo here. All my years in the legislature, I've come to the conclusion that it's much more important sometimes what a bill doesn't say than what a bill does say.
And then I asked the other question was just, do you have thoughts about if there could be a way that we could maybe have a better procedure where folks at the facilities could more readily, more quickly elevate concerns to district attorneys or to courts about incidents, to your point, that a district attorney or a court may not be aware of, but that may have taken place. And I think it's a well-taken point that that may currently take some time necessarily to reach a DA, but it seems like that could maybe be overcome if we had a better process for quickly elevating those issues.
Thank you for the question. The intricacies of what goes on in the juvenile detention center, I'm not intimately familiar with because deputies don't work there. That's juvenile corrections, so that would probably be a more appropriate question for them, other than sometimes we help with transport, and then obviously we're in the courtroom for security purposes. I mean, sometimes informally word can be got to the deputy, but again, then it's a matter, can you get that to the prosecutor to get it in front of the judge? So.
Thank you. I did want to point out to the committee that we do have a copy of the fiscal note for SB 321 requested by Senator Pyle has been distributed to the committee members to take a look at. And with that, questions from Senator Baumgardner for Mr. Smith.
Thank you, Madam Chair. And I guess I'm just going to kind of follow up or circle back around with the question that Senator Corson asked. And that, you know, when we had the hearing in the interim where this was specifically discussed and addressed, part of the testimony was what was going on already, that presumption of innocence and not shackling was the procedure that was being used in Johnson County. And part of what was shared is making sure that that was consistent throughout the state. So I'm a little curious, could you be more specific about what is it that is the practice now in Johnson County that might be negatively impacted by this law?
Thank you for the question, Senator. First off, I guess I should probably make the distinction between restraint and shackling. Those are different things. Shackling indicates that the ankles actually have some type of mechanical device on them to prevent easy movement of the feet, whereas restraint refers more to the hands. As I read this bill, it talks more about restraint. I don't even know that the word shackling is in there. I may have missed it, and I don't have the bill in front of me right at this time. But it is not the policy right now in Johnson County to shackle a juvenile. Hand restraints are used to the extent that they're able to still participate in the proceedings or look at documents and that type of thing, but they're not always restrained. It comes down to really what the court wants.
If I might, Madam Chair, we do have in there, it's on page 6, it's FF, lines 1 through 4. Restraints mean handcuffs, leg shackles, leg irons, belly belts, belly chains, or other restraint or devices used to restrict a minor's free movement of limbs or appendages, including those made of cloth and leather. So I guess the other question is, knowing that perhaps not exactly identical to this language, but in 33 other states, when the sheriff's office was reviewing this particular piece of legislation, did it come up with problems in other states that have this legislation in place?
In the states that already have this legislation?
Correct.
I'm not aware of any particular complaints that have come out of that. I'm also not aware of any stellar successes either, so I don't know which way that would go.
Well, I think based on the testimony, Madam Chair, it is that additional harm, be it physical or emotional or mental, would not be caused on the minor that was shackled. And some of the examples that were shared is times that when there's a series of hearing, that youth are actually shackled to each other until it's time for them to have their hearing in the courtroom. And so I think that we did have information that was shared not only today in testimony, but also during the interim as far as the negative impact of shackling, where it certainly does not indicate that presumption of proof. So I appreciate the comments from the senator.
Madam Chair, if I may.
Sure.
With the passage of SB 367, whatever, 6-7 years ago now that it's been, there has been an increase in training in law enforcement on trauma-informed handling of juveniles and that type of thing. So law enforcement is now being trained in that as well as every other thing that we get trained in.
Thank you. Mr. Smith, I understand your role at the Johnson County Sheriff's Office, and you are not in the Juvenile Detention Center. Do you have any information to provide the committee about as the bill is written, to get that kind of information if there's going to have to be a hearing on this issue? Is that something that our system is equipped to do, that could be efficient, or would that delay justice for the juvenile, or do you have a sense of how that would work?
Again, it's going to depend on how that hearing mechanism is set up. I mean, that obviously could cause a delay if there has to be an additional hearing before we can have the hearing that we need to have. And I would say from the Sheriff's Office point of view, our main concern is the fact that the bill doesn't say that if there's an issue in court, can we take action? Can we restrain that juvenile if they make threats to the judge or the DA or the victim in court or whatever that happens to be? Because the bill is silent, we're kind of up in the air on what we can do.
Thank you. Committee, any further questions? Seeing none, then, oh, yes, Senator Corson.
I guess that last piece, you've said that a couple times, that doesn't seem very compelling to me, because I just think it's obvious that in the moment of a security issue arising in court, that the deputies would have the ability to act properly to reduce an immediate threat or risk. I wouldn't think that would normally have to be spelled out in a bill. I mean, that would seem almost out of place. I mean, that's sort of like needing to specify that they're specifically able to do their job. I mean, there's right now presumption against adult shackling, and I'm not aware of any language that says that if there's an issue with an unshackled adult, that specifically gives sheriffs the ability to respond to an in-person, actual in-the-moment security threat. So I just, that piece in particular stuck with me as not really, I mean, we could add that to the bill if that would assuage reservations, because I think it's already just kind of an obvious thing that is in place. But I mean, I'd be glad to carry that amendment if that was the sole objection, because I just don't think that it's really a real live issue. But thank you. And I don't know if you want to respond. Maybe I'm missing something. Thank you, Madam Chair.
Thank you, Senator Corson. You're entitled to your opinion, of course. But in today's society and law enforcement, we find it's a lot safer not to assume that we can do certain things, and that we would feel more comfortable if it was spelled out in the bill.
Thank you. Thank you for your testimony today and for appearing. I have a question for maybe research. In some of the proponent testimony, there's a statement that the use of shackles and restraints on children is contrary to law. Is it accurate in Kansas that practice is illegal? I found that statement interesting.
Madam Chair, this is Natalie Nelson from Research. I do not know what that statement is referring to. I can definitely look into it a little bit more and get back to you.
That'd be great. Thank you. Wanted to bring the committee's attention. We do have, are there any other neutral conferees in the committee meeting room or online? I think we had asked earlier, and hearing and seeing none. Then we're moving on to opponent conferee testimony. Are there any in person in the committee meeting room or online? Don't see any. We do have opponent written testimony in your committee folder. The Honorable Merlin Wheeler, Chief Judge, Kansas District Judges Association. And I did want to point out to the committee some of that testimony. Senator Pyle had referred to some of it earlier, and noting that the Kansas District Judges Association, the committee includes judges from the 23rd Judicial District, the 10th, the 7th, and the 12th, and that it's the collective experience in handling procedures under the Kansas Juvenile Justice Code that the use of restraints during hearings is by far the exception to the normal practice and does not generally occur absent a demonstrated need. And they did then also mention that prior to authorizing use of restraints, the bill would require a court to conduct a hearing and make written findings in support of the use of restraints. So if you just want to take a look at their written testimony, it's in your folder. You can do that. Do we have any other questions or comments in the hearing today on SB 321? Yes, Senator Baumgardner.
Thank you, Madam Chair. I will simply comment on the opposition testimony, and it's unfortunate that none of those judges are available. But what's interesting about the testimony is actually they're arguing both sides. On the one hand, they argue essentially this legislation is unnecessary because it hardly ever happens. But then they argue against it also because a hearing would cause a delay in the process. Well, which is it? Is it that the judicial process is going to be slowed down, or we don't need this because it rarely ever occurs? I feel that, if you're looking at that, they almost cancel each other out. So I just wanted to put that forward. I did also want to share that it was a unanimous vote of the committee. So for Corrections and Juvenile Justice Joint Committee to ever have a unanimous vote, and I know that certainly Senator Wilborn can speak to this because he's been served on that committee for several years now. But for us to have both the Republicans and the Democrats to come together, we only found two things that we could be unanimous on, and this is one of them. So just wanted to share that with the committee. Thank you, Madam Chair.
Thank you, Senator. Committee, we do not have any other items of business on our agenda today. So with that, we are adjourned. Thank you very much.